All right, our next one up is Bethesda Hospital versus John Crossley.
Good morning. May it please the court, Bill Bigger here along with Timothy Kennison on behalf of Bethesda. We have an appeal in this case and we have a cross appeal. I would like to take 9 minutes initially on the direct appeal that we raised. I would like to save 5 minutes to respond on the cross appeal and 1 minute for a final rebuttal if that pleases the court. Okay. Thank you, Your Honors. The briefing is very comprehensive in this case, as I'm sure Your Honors know. You read these briefings in advance. We weren't short on the briefing. I think virtually everything was covered. In preparing for this oral argument, it came to light to me that there were a few things that were some very simple points that got a little bit lost in the complexity of the briefing that I thought would be the appropriate time this morning to bring to Your Honor's attention what we think is really important. And what I want to explain is this was a medical malpractice case about an alleged misdiagnosis on a radiology read. We have two radiologists at Bethesda, Drs. DaCosta and Dr. Adami. The plaintiff came in May of 2010 from MD Now. MD Now sent him to our hospital to rule out pulmonary embolism. All undisputed. Dr. DaCosta looked at the scan, said, I see pneumonia. I don't see pulmonary embolism. Dr. Adami, radiologist number 2, looked at the scan and said, I see pneumonia, not pulmonary embolism. The patient, plaintiff, was treated for pneumonia, sent home, told to follow up in 2 weeks if he wasn't doing better. He was doing so much better he didn't follow up. 4 months later, plaintiff shows up at JFK Hospital. He's got a pulmonary embolism. What happens at JFK? They initially say, we think it's pneumonia. He's 27 years old. He's not a candidate for pulmonary embolism. It's off the radar. It's on their differential. Eventually they diagnose it, but not for a while. In the meantime, he suffers a cardiac arrest and the damage that he sued for, which was significant vision loss and some collateral neurological damage. Those are the facts. What happened, and this is really important, is when plaintiff was conducting their pre-suit investigation, I know Your Honors are familiar that in medical malpractice you can't sue until you do a pre-suit investigation. Plaintiffs have to get the records, they have to review the records, they have to give their records to their expert, and they have to obtain an affidavit from their expert saying, more likely than not, negligence. So plaintiffs did that. There was one little mistake in this case that led to what we assert is turning the case on its head.
Can I just get to the nub of the issue? If it's one little mistake, then it shouldn't be much ado about nothing that the jury hears this and we can defeat that much ado about nothing and the jury can dismiss it as being much ado about nothing. But if it is something, the whole question of 403 analysis that you all bring in, that implies that it's probative, but the question is it more prejudicial? So I guess I'm asking two questions. One is, so it seems like you're trying to have it both ways. It's not a big deal, but it is a big deal. So enlighten us.
I think Your Honor hit the nail on the head, but I think it went the other way. It was had it both ways was on the other side. And here's why. Here's why. Because the first and only mistake in this case was when plaintiffs first asked Bethesda, give us the wet read. That's the initial interpretation. Someone, Marissa Jurinsky, went and said, I went to radiology, I don't find one. There is no wet read. I think I told that. Then They finished their pre-suit. They included Dr. Guzman, the ER doctor, because of that. They said, well, if there's no wet read from radiology, then Guzman, the ER doctor, must have interpreted. They included him in the pre-suit. Big deal. Pre-suit happens. Lawyers get involved for Bethesda. And they said, you gotta look. There must, plaintiff's expert, Dr. Bierhall, said, there has to be a wet read. The radiologist had to look at this. We go back and we found, yeah, the history shows the way it works is Dr. DeCosta typed in the computer, it gets faxed to the emergency room. Dr. Guzman, the ER doctor, got the wet read. There is a wet read. It's in the emergency department. He looked at it. Plaintiffs, this is really important, plaintiffs met with Dr. Guzman, as they're allowed to do, because it's a treating physician. They showed him the wet read, which I have right here. They showed him this document, paper, this is important, paper, not computer document. Remember, our whole argument's about Sharp was a mistake. That's a computer expert. Paper document went to the ER. Undisputed. Plaintiffs met with Dr. Guzman, showed him this, said, is that the document you saw in May of 2010? Is that the diagnosis you got? Is that what you relied on? Yes, yes, yes. That's plaintiff's case. This piece of document. And really important, because their entire case was predicated on their theory that this report showed that the radiologist was wrong. Says, I see pneumonia, no PE. They put that up in their case in chief. And remember, the whole case was discovered, pled, and discovered up until the summer of 2015, all on this. Then another lawyer came in.
If I just move it along a little. Let's say that in your reciprocal discovery found out that the plaintiff had failed to mention a prior condition when he or she was checked into the hospital. And then, so you start digging at that, and all of a sudden, this patient, who's a plaintiff, tries to contact, maybe he went to a physician that he knew, and all of a sudden, changes were in his record to omit the prior condition. Wouldn't you say that was probative?
I would, Your Honor, and here's why that's a totally...
Now, and they're going to come back and say that that was a computer mistake, there's no evidence that he changed anything, and you're going to say, how do we know? Because we don't have the record there. And you're going to say, let the jury decide.
And here's, and that's completely right. But here's, again, I feel like I failed to make the point to the trial court. I don't want to fail to make the point here. It was all irrelevant, and here's why. The diagnosis in this case was conceded. What happened at Bethesda in May of 2010, everybody agreed about. There was no jury issue. Zero jury issue.
Yeah, go on.
The plaintiff came to Bethesda in May of 2010. The radiologist didn't see a PE. They saw pneumonia. He was treating him for pneumonia. He left. They sued. They said that was negligent. There are two kinds of medical malpractice cases. Some medical malpractice cases, there are facts for the jury to determine about what happened. What treater did what did they say, who did it, who was responsible. There's another set of medical malpractice cases where it's absolutely undisputed what happened, and the only issue is for the experts. The doctors did what they did. Was that standard of care, or was it not? We're in this subset, and that's the critical distinction, is there was never an issue for the jury about what happened at Bethesda. At Bethesda, everybody agreed from day one. The radiologist saw pneumonia. They did not see a pulmonary embolism. Boom! We're going to trial on a stipulation. Look at the stipulation, because we talked about that. We were going to trial on, this expert says that's a deviation from the standard of care to miss the PE. This expert says, I look at it, there's no PE on there. It looks like pneumonia. That was supposed to be the trial. That's what we prepared for in all of discovery. And then on the 11th hour, a month before trial, they say, way back.
Couldn't there, okay, well, the timing of it was, you didn't go to trial in November, I believe, you were told about this in March. So could you have had an expert to look at their audit and say, that every time it said a mistake or a change, it really wasn't, it was just viewing it, and it, I mean, if that's your argument, that nothing was changed, yeah, I mean, didn't you have the opportunity to bring in the countervailing to Mr. Shaw?
So, the answer to your question is yes. The dates you've cited are wrong. We did not know in March exactly what this
When did you know? Well, you didn't take his depot,
July.
but he was, when was he listed as an expert witness?
He was listed in February with a disclosure that said nothing about all these and remember, it's not just about an altered record. What he ultimately got to say, based on the judge's ruling, was, oh, once they knew they were getting sued, they kept going in and looking at the records, the two radiologists. Incomprehensible that this comes in a medical malpractice case. You're in a pre-suit discovery, you know you're getting sued. Of course they look at the records. Between the two of them, he said 25 times. When I'm working on a case, I would do, that's 12, 13 times per defendant. I would do that in one day, much less the 90-day investigation. But I don't want to miss your question, which was, let's get the date straight. They disclosed him in February. They did not say he's going to be an expert on altered records. There's a brand new issue in the case, which would have made no sense. Because remember, our record, they relied on. They showed their experts. They had their experts testify about. They showed the treating physician, Dr. Guzman, to confirm that is the correct record. I relied on it. Dr. Guzman was their star witness by depot at trial. So the idea that we would be thinking that they're going to inject an altered record theory in the case when their entire case is predicated on the initial read and the final read that say no PE, which is their theory of negligence. So when they write a brief that says...
Couldn't the record have had, as opposed to this sort of dispositive existing, non-existing, but the doctor could have described conditions or could have described other, which would have been, to an expert, would have been an indicia, and said, you missed that, there was this, this, and this, by viewing the
A CT.
CT CAT scan. Okay, so by viewing the CAT scan, they would have been able to maybe describe what they viewed, and that description may have been to an expert proof of the PE, and therefore that could be their argument, obviously. So I'm not sure that one side or the other gets to decide what's relevant evidence and argue, but it seems to me you could argue the total irrelevance of it.
We could, Your Honor, but when you look at the record in toto, remember, what we're complaining about was a motion before trial. Remember, and I have to make sure the three of you understand, in June of 15, when we were starting to do this trial, the case had been totally discovered, it was pled. The allegation was the radiologist missed a pulmonary embolism. The experts were all deposed. Plaintiff's experts were deposed. Then they give an affidavit, and it might be important for you to understand. We did a motion for summary judgment on corporate negligence because they were alleging that we were responsible for these radiologists on a theory that they should not have been on staff. It was only then, in the weeks before trial, they filed this affidavit from this Mr. Sharp, who said, oh, I think there's a bunch of alteration of records here. Talk about a surprise. They built their whole case on our records. Our records said radiologists did not diagnose PE. Allegation is they failed to diagnose PE. What are they talking about, altered records? So, first of all, you understand busy litigation. You think, well, that's not going to go anywhere. That's the most ridiculous thing I've ever heard. But we go to the hearing. We have a brand new judge who just come out of the prosecutor's office. And this is important, actually. We show up at the hearing. I'm thinking, they got nothing. This is ridiculous what they're arguing. And the former prosecutor, now working for plaintiff's firm, argues at the hearing, why is it relevant? Because I said, not relevant. The record is the record. They rely on the record. You're trying to impugn the integrity of the doctors and the hospital saying they altered records, but it's the exact records you're basing your entire case on that's consistent with your whole case. So how are you going to do that What do we hear? Consciousness of guilt. A criminal theory. Oh, they got a notice of intent, they found out they were getting sued, and what Adam Sharp wants to say is, oh, once they found out they were getting sued, they started to look at the record. And, this is really important, he says they updated the record. They didn't just read the record, they updated. Then he's asked, Siemens is the production company that did this software. Did you contact them? Did you review anything? Do you know anything about how they do their defaults?
Would you put anything in the record to countervail this theory of the 25 updating and the one that's 2 years later that was updated?
We absolutely did, Your Honor, and I would implore this court, if for any crazy reason you were inclined to affirm this, you can't affirm this if you don't read the testimony of Ann Osowski. She is the person who's worked for 20 years at Bethesda, who's worked with Siemens, who's been all the updating education on Siemens. She explained all of this, and on the issue you're asking about, she specifically said, it's cited in there, you can read her testimony, she said, the way Siemens set up their program, which Adam Sharp knew nothing about, is that when people who are not authorized radiologists, and there's a word for it, clinical people, no, there's a different word, but people who are not radiologists go in, every time on the audit trail, that will show as read, because they're looking at it. When radiologists like Dr. Dami and Dr. DaCosta go in, every single time, no matter what they do or don't do, it says update. So when Adam Sharp had testified, classic users, it says read. Radiologists, it says update. That's undisputed. What did Adam Sharp say about that? I don't know. What did he really say was, would you defer to someone who understands the Siemens system, has worked for it years? I would defer. So now we're in the trial. Now we're way down the road. And I don't want to miss this. Did this become a feature of the trial? Because that sounds so cliche, and I'm reluctant to use that. I don't think I've ever used it in an appeal. But I lived this. I was there making these motions and arguing this. We were supposed to be asking the jury to decide, did the radiologist miss a PE as they documented in their records? And their expert would say, that's fine, or did they not? Is plaintiff's expert correct? And the whole focus of the trial, the train went off the tracks. Over and over and over, the trial court allowed plaintiff's counsel to ask questions of virtually every witness about altered records, changed records, all of which are explained. They say in their briefing, we didn't explain all these anomalies. Our witnesses explained every single one, and when I get some rebuttal time, we'll talk about that. But the key is, a couple weeks ago, this court, Your Honor's court, issued an opinion and said, in our new world where jurors can ask questions, when we're looking at the issue of did this affect what the jurors did, we have a great new tool. Were there juror questions? And this is the State Farm versus Figueroa case from February 8th from Your Honor's court. It's not final, but I think it's very illustrative. In this case, when I'm telling you, it's one thing for me to say, I was there and I lived it and went off the tracks. What happened? Were the jurors confused? Look at the record. Did they ask a question about altered records? Yes. Once? Twice? 3 times? 5 times? 10 times? 15 times? 22 times. To multiple witnesses, the jurors were asking questions about altered records in a case where the plaintiff based their claim on the record that was produced in discovery, which was the paper record that there is zero evidence was altered. Dr. DaCosta said no pulmonary embolism, PE. They based their entire case on it, and yet we spent 4 weeks in trial where virtually every witness was asked about Bethesda altering their records to the point where the jury was asking questions over and over and over again about it. And then all of this got punctuated at the end when plaintiff's counsel said, we should get the adverse inference instruction that tells the jury, if you've heard any evidence that records were altered, you can infer that all of that would have been bad for the defendant and rule against them. It's a very uncommon jury instruction.
Did the JFK appeal?
JFK was never, this is the bizarrest thing about this case. The pulmonary embolism that was undisputed, and no one disputed existed at JFK, the plaintiff didn't sue JFK. There was a delay at JFK, they thought it was pneumonia, they didn't give TPA right away when they could have. JFK should have been the defendant in this case. That's what's so insane. You have to wonder about the connections, and we always did.
Although, wouldn't JFK be saying, as a result of your arguments, that nobody's pointing the finger at us for altering records, and we got swept away in this?
No, if JFK had been named, they would have had but one thing they could have done. They could have argued, we correctly treated the patient as he came in, we weren't required to see that he had hypercoagulability, our delay in giving TPA was within the standard of care. That is exactly what they would have had to. And you know, there was a very small part of this case on our affirmative defense where we had to present the negligence of JFK, and it didn't take much, and the jury accepted JFK was negligent in not giving the TPA right away, and they apportioned 40% to JFK based on it. JFK would have been in a hard position had they been sued. The truth is, Your Honor, this case should have been against JFK.
I understand, you're 5 minutes over all of your rebuttal, so I'll give you a couple minutes though, so I'll go to the other side. Now you all then have 7 more minutes than you would have had to match up with the 5 you've already taken, and the 2 I'm going to give them.
Thank you, Your Honor.
May I please report, I'm Philip Burlington here on behalf of John Crossley. With me at council table is Darrell Lewis, one of the trial lawyers. It is absolutely incorrect to stand before you and say all the anomalies were explained, and it's also incorrect to say that they were in any way sandbagged regarding this being an issue. And in our brief, we were very clear that the 2 radiologists whose depositions were taken even before Sharp could not explain certain things in the record. But I'm going to go back with a chronology to make it clear not only that this wasn't all about one statement Bethesda made prior to suit, that it is a constant thing in these records. 2 of the critical records that were in the medical records when we asked for them say on their face they were generated a 1.5 or 2 years after the treatment. And no one from Bethesda ever explained what happened to the originals and why they generated these documents 18 months, 2 years later, and then they expect us to accept those. Now, when he says we relied on the medical records, that's what you have to rely on. And that's why it's critical, because we don't have anything else. We had no witness there. We have their medical records. And, as I will make clear in a minute, each of these radiologists and the emergency room doctor testified uncritically. They don't have any recollection of what happened. They are relying on the medical records. So when he says the testimony of the emergency room doctor proves that this was what was done and this is what was said, if you look at page 3008 of the transcript, Dr. Guzman testifies that everything he testifies to is based on the medical records. He doesn't recall what happened, but let me give you a little chronology. As in any medical malpractice suit, plaintiff's firm asks for the medical records from the hospital. Needless to say, especially when it's Cersei Denny, this sets off the light bulbs. Okay, they get the medical records. The wet read or preliminary report is not in it. It was not during pre-suit, it was prior to pre-suit, and in fact, if you look at page 11 of their reply brief, they say the trial court's admission of Bethesda's pre-suit response to a records request. It was not during pre-suit, it was simply a written request saying, we have the medical records, we don't have the wet read, can you please send it to us? The response from the lady who has 20 years experience as the head of the Department of Health Information, i.e. the records of Bethesda, was that she spoke to radiology, no wet report was done. Okay, then we proceed on. Subsequently, we are provided with a blank preliminary report. It has the date of birth wrong of Mr. Crossley. It has his age wrong. We also have testimony of Dr. Adami that when she went back after she was aware of what was going on and looked at the record, looked in the computer, the wet read report was blank. That's what she testified to. Then a little later, by the way, that first blank one is at page 2703 of the record. It's also in my appendix to my brief. Page 2705, they then produce another wet read report, which now says no PE, left lower lobe pneumonia with small left pleural effusion. Now the date of birth is correct. Now the age is correct. And Osowski later characterized this as a result in response to a jury question. That was an update in the medical report. That's at page 4081. If you look, you'll see 5 other discrepancies between the blank report that was produced to us and the one that has actually some content. And when I mean discrepancies, you look at the top and there's various information. There's 5 others that I haven't even mentioned.
Let me say a question. I'm aware of everything. I'm aware of everything you're mentioned. We're all aware of all the changes.
Oh, okay.
But the question I want to know is, what relevance is the fact that his age, I think instead of 4.3, it was 4.30, the fact that all these different changes, what relevance does it have to your lawsuit? How is it relevant to the jury?
Okay, it is relevant to the jury because, as I mentioned earlier, and I'll be more specific on here, their primary witnesses, the 2 radiologists, especially Dr. Adami, who did the final report, testified at page 3458. Do I recall anything about May 23rd, 2010? No. And the other question is, okay, what you know intimately at this point is what the records say. Correct. And he says correct. And then plaintiff's counsel says, and if the records, for whatever reason, are inaccurate or unreliable, then your testimony is based upon an inaccurate and unreliable foundation. Is that fair? Answer, that sounds fair, yes. Because the problem is, as was admitted, whatever was done, and I'm going to get to the audit trail in a minute, whatever was done was purged. Any changes that were made other than to this top part, which has what I'll call the basic information, which changed for various reasons, it was purged. They admit it. We were unable to prove. Now, he says, well, the whole thing was whether there was a pulmonary embolism, and it wouldn't matter because that's on the documents we gave you. Well, they could hardly avoid that, given that they didn't give him anticoagulant treatment. And I should say our expert looked at it at the CTA scans and said, I would expect a second-year resident to identify this pulmonary embolism. And when he went to JFK 3 months later, it wasn't just that he had a pulmonary embolism. Even their experts said he had massive, multiple.
But that proof would have been in the record as part of the CAT scan. There's no allegation of any doctoring of the CAT scan. So
correct.
Your case would have been able to go forward with or without this.
No, I disagree because their defense was it wasn't a pulmonary embolism, it was pneumonia. So they can change things in the record to strengthen that defense. For example, you look at the final report that was generated 18 months, 2 years after the accident, and you look at one of the things said in there is there is suboptimal timing of the contrast bolus. Now that sounds like Greek, but as the testimony came out, that is a statement that when the contrast is injected, the CTA scan is supposed to be timed so that the contrast is in the area of the body doing what it should do to heighten whatever is being looked at. And what that statement is saying is, well, the timing wasn't so good. It undermines the reliability of that CTA scan. So whether or not that was truly in the original report or not is clearly a factual question. And I should add, Dr. DaCosta, who did the preliminary report, she testified that I was supposed to confirm the existence, or confirm the diagnosis of pneumonia. That's what she said she was supposed to do, even though she, then we get a preliminary report that has no PE on it, okay? Maybe it was there before, maybe it wasn't. But everybody has to base their testimony on these medical records, and when they have no explanation why 2 of the critical documents, and let me get to the patient contrast questionnaire, which Dr. Adami testified she relied on for her testimony. That's another document that was on its face, generated over 2 years after the treatment. And if you look at it, it says on its face, This document was modified on June 6, 2012, from documents prior to June 6, 2012. We never get those prior documents. Nobody explains who did it, why, until late in the trial. And bear in mind, on the evidentiary issue of this, Osowski's testimony didn't come until December 10th in the trial. That was at the end of the defendant's case. The motion in limine was held in October. Sharp's testimony was presented on November 30th. They had no explanation. At the time the judge made those rulings, Osowski's deposition, she was clear 3 times. I don't know the difference between read and update in the audit trail. And this audit trail could show access to these records during a critical time, when they knew there was going to be a lawsuit. And our experts said, based on my experience in computers, the read is a passive look and an update means you change something. He said it could be a comma, it could be anything. But that's the only testimony. Barbian, their 20-year medical records specialist, said she didn't know anything about the entries in the audit trail. Osowski said, I don't know what the difference between read and update is. That's what the trial judge had before her when she ruled. At the end of their case,
about the trial judge ruling, I will confess to you that one of the statements made by the trial judge during this banter that occurred with the objections flying around was, as your colleague suggested, a standard built on consciousness of guilt. And that, of course, as you know, is foreign to this civil context. So,
no, it is not.
Well,
I must disagree.
Well, explain it to me. Show me, if you would, where there are cases that deal with these types of issues that talk about consciousness of guilt being, as the trial judge in this case said, a fact for the jury to decide.
For example, in a car accident where somebody causes an accident and they flee the scene, that is evidence that they knew they were negligent, they knew that they caused the accident. I agree, it comes up very much in criminal, but it also comes up in civil. And there is a great quotation that this court has taken from McCormick that says it is one of the basic reasonable inferences of common sense that if somebody either alters, destroys, modifies evidence, that you can infer that they had some self-interested reason to do so. But it is also...
Would you concede, though, that in the civil context, it's not framed as consciousness of guilt?
I'm sorry?
Would you concede that in the civil context, the courts have not referenced it as consciousness?
Oh, okay, because guilt is not
Right.
the term. And the jury wasn't instructed here about consciousness of guilt. We argued 2 things. We said when they alter records, and candidly, they've never explained what happened to the original final report, the original patient contrast questionnaire, and until late in the trial, after the trial judge ruled, they had no explanation for the updates in the audit trail. Osowski, who they then relied on, suddenly was educated, and by the way, she admitted she had no computer experience or training. She was a radiology tech who worked in that job. But at the time the trial judge ruled, there was no explanation other than our computer expert who said, this is what's standard in the profession. He had worked also with healthcare computer systems, and he said, this means something was changed. I don't know what it is. We can't prove one way or the other. But we also argued that their claim, you see, their whole thing was, it was pneumonia, and they brought in an expert that said, oh, no, that's pneumonia, it's not a pulmonary embolism. So they could have changed many things, including the suboptimal timing of the contrast bolus. The contrast questionnaire, Dr. Adami testified explicitly that she relied upon it. She would have access to it when she did her report, that she relied on it.
One of the concerns I have about this is sort of where it becomes a centerpiece of a trial. And in other contexts, we the courts have been concerned about where, for example, Stewart v. Hertz, where you have a normal accident, and then you have defense saying, blame the doctor. It was the doctor's fault. And then we have said, we don't want to have a trial within a trial. We want to worry about the claim, the primary claim. My concern is that the way IT works in many institutions, especially in healthcare, we're going to start seeing Mr. Sharp or Mr. Sharp like witnesses in every case from now on, because they're gonna become like trials within trials. So why, why wouldn't this be a concern, and why shouldn't we worry about this sort of 403 analysis where it's clearly probative, at least that's how I look at it now, but I'm sort of concerned about the prejudice and the sort of taking over a trial, and that every time in the future we're going to see this as another centerpiece of a trial, and then juries may rightly or wrongly be suspicious of institutions and say, aha, alteration.
Okay, I would first point out, they put 40% on JFK. They obviously weren't unreasonable there. And by the way, JFK was not a party in this case. They were a Fabre defendant. So they were not there to defend themselves. We had to defend them as well. But getting back to your point, Florida Supreme Court has said that 403 is to be used sparingly. It's a drastic remedy. But I agree with you, there will be situations where there is not enough to go on and a judge can make a 403. In this situation, when this trial judge made the ruling on the motion in limine on Adam Sharp's testimony, Bethesda had provided absolutely no explanation, and they still haven't, for why the final report was generated 2 years after and they lost the original, why the patient contrast questionnaire was generated 2 years later and they have no explanation. And by the way, Osowski ultimately testified in the trial, oh, I was the one that changed the patient contrast questionnaire. This is after years of litigation for prior deposition. And she was asked, well, why would you go in and change it 2 years later? And she had some statement about, well, I wanted to say restore the lot number and volume of contrast, 3979 of the transcript. And when he said, well, why would you do that 18 months after treatment? Answer, I'm not really sure. Now, this was a case, and again, in a medical case, everybody has to rely on the records because it's years later and our experts weren't there, and generally the defendants and their witnesses have had years of dealing with other matters. But in this case, it was so bad at the time the judge ruled. Maybe it would have been different if they brought in Siemens. If Osowski had been educated, which he was at the end of trial, but still, she didn't explain many of the anomalies.
Let me ask you this. Your opponent suggests, though, that you all, in your pretrial stipulation, stipulated to the authenticity.
No, we did not.
That is not a,
no, and in my brief, you'll see the very clear statement, and I quote it. All we stipulated to is it's not necessary to call the records custodian to authenticate the records. So what we agreed was one prerequisite didn't have to be fought. That's all we agreed to, because this was clear a year before trial when the depositions of Dr. Adami and Dr. DaCosta were taken, and these anomalies in the records were noted. And so this was unfortunately a case where we were put at a disadvantage, and certainly it would be unreasonable to hold that when a patient is bringing a medical malpractice action, the hospital can generate documents years later, not have the originals, and say, well, you're stuck with these, and the jury's not supposed to know that, we don't have the originals, and these say they're modified, or these were generated 2 years later. That would be just absolutely unreasonable to any sense of fairness in a trial. And the trial judge, there were numerous witnesses on this because we asked the witnesses, what did you rely on? That's in every trial. And when there are so many problems with the records, it will become a feature of the trial. And we have no choice because we believe it was clear that this was a pulmonary embolism, and they're saying it's pneumonia. And if they thought they were dead to rights, why were these documents not in the medical record? And I would add that it turns out that their medical records lady, Ms. Barbian, testified that, we shred the preliminary report 24 hours after discharge of the patient. Our expert testified that that would be simply, he's never heard of such a thing. That's unbelievable to shred a medical record. So this was a case where this became an issue because of what happened on this side, and we had to deal with it. Now I'd like to touch briefly on the cross appeal. This was a case where the jury obviously found that they misdiagnosed the existence of the pulmonary embolism. That being the case, the only reason, and the testimony was if he had been given anticoagulant therapy during that time period, it would be a less than 1% chance of recurrence. If he did not get anticoagulant therapy, which he did not, because they did not diagnose it, he would have up to 100% chance of reoccurrence within the year. Well, 4 months later, he had what their expert described as massive multiple pulmonary embolisms in his lungs. And so the only reason he went to JFK, and I don't think anybody disputes this, was it turns out because of the pulmonary embolisms. It was not a separate condition. And in that situation, it's clear, and there's multiple cases dealing with it in a healthcare provider setting, that the Stewart v. Hertz principle applies, and that it is not necessary for a separate injury. There's a failure to diagnose case involving Hodgkin's lymphoma, looking at a CT scan. It's not a separate injury, it's whether they aggravate or add injuries. And in this case, JFK, even assuming they were negligent, it falls on them because at most they aggravated the existing anticoagulant problem as evidenced by the pulmonary embolisms, and I'd like to retain 225 for rebuttal on the cross appeal.
Thank you, Your Honors. If I can take just a second to respond on the direct appeal and then the cross appeal. A couple of very, very important points. In my comments, I want you to put in 2 boxes. The first box is over here, which is please remember what I think I failed to convince the trial court of. The records are totally irrelevant. So this nonsense about altered records, which I'm going to tell you over here, we explain, is totally irrelevant, and the judge failed to do any 9403 balance. 0. There's none. She never said, I find there's some relevance and it's not substantially outweighed by the prejudicial effect. Didn't do it. She just said, consciousness of guilt, that's pre-trial, on my motion eliminating on sharp. She said, I'll let the jury figure it out. She did no way. So, irrelevant. And why do we know for sure it's irrelevant? Because plaintiff's expert, Dr. Beerhals, their radiologist, was asked and said, and it's in the record, and we cited it, do you need the records? He said, I've got the films. All I need are the films. I don't need the records. The films, he said, show pulmonary embolism. That was their case. That's what our record said, was we didn't see a pulmonary embolism. There was never any dispute about, our records couldn't have been better for them, is the point, really, when you think about it. So, we went to trial on the films. Our expert said the films don't show a pulmonary embolism. Their expert said it does. In July of 15, they got this new trial judge to say, I'm going to let you talk all over the place, not only about altered records, but about looking during pre-suit, looking at the records. Now, something you never hear of, and there were some questions from the panel about, is this going to create a new world for medical? Of course it will create a new world. If you affirm this, the discovery is going to be totally different. Trials are going to be totally different. They're going to say, you got notice of intent. Did you look at the records? Oh, that sounds bad. You're going back and looking at the records. How many times did you look at the records? Never comes in. Shouldn't come in. Was improper to come in this time. And totally irrelevant because the diagnosis was conceded. There was nothing about what happened at the hospital that was disputed. The only thing the jury was looking at was which expert do we believe? We have the films. Bethesda did not diagnose a PE. They said it's pneumonia. Were they right or were they wrong? That was supposed to be the trial. Instead, as you hear from this long oral argument and 200 pages of briefing, everything's about altered records. So let me step over here and say, every single thing they call an anomaly was explained. They say, oh, the age is wrong. Well, Adam Sharp didn't know nothing about that. No plaintiff expert knew anything about that. Ann Osowski got up and said, our system updates that. When you print a record 2 years later, it updates the age.
Why would it update the date of the birth from 03 to 30?
No, that one's a little trickier. It updates the age. That one, she said, we had different face sheets when it got input into the computer on 2 different admissions. One date of birth got entered, and then a subsequent date of birth got entered because there was a December 2011 admission, which explains another one, what they call an anomaly. And she said the template corrects it. It goes with the most recent date of birth. But that truly is something that was just a mistake. Someone put the wrong date of birth in on one of the two admissions. But as Your Honor pointed out, the relevance of that's something that happened years before. It's not an altered record. They use that to emphasize, oh, Bethesda just alters their records. But on the key things, what they can't get around is the initial read. And remember, there's one read by DaCosta, that's the initial. Patient's discharged before the final read by Adami comes in, which is totally consistent with the initial read. The undisputed evidence was the final read can't be changed. If you change it, it's called an addendum. You can't just sneak in there and change it. Adam Sharp didn't say anything different than that. So the final read says pneumonia, no PE. It's consistent with the initial read. And the initial read is faxed, undisputed, faxed to the emergency room. They put their witness up, Dr. Guzman, who said, I saw the initial read. I saw it said pneumonia, not PE. I contemporaneously wrote that in the medical records, which they don't challenge. He wrote it in there. Radiologist says pneumonia, not PE. Totally undisputed record. And look, and you'll have it, Your Honors. You'll have the preliminary read. It's got the fax date and time across the top, May of 2010. The record that mattered in this case is undisputed. No one said this paper record that printed out on a fax machine in the emergency room in May of 2010 is altered. They didn't have one person, Adam Sharp didn't contest this, nobody contested. In fact, they put their witness up, Dr. Guzman, who said, this is the correct record. But, I can say that to you now, it was completely lost on the jury because every witness they put up, what the trial judge did was let them ask every witness about everything. The age doesn't match it. And in fact, we point out in the brief, they even put their own expert up at one point, and they redacted a record. They took out something, and they said that, oh, this record's even different again, isn't it? To emphasize to the jury that, oof, gosh, it seems like they did it. Undisputed. It's in our briefing. We cite in there with their own expert. So, the only thing I'll say on the cross appeal, because I'm running out of time, this court...
You're way over time, way over time. I'm trying to be fair to your opponent.
So, Your Honors, on the cross appeal, this court's already decided the issue in Letzer. In Letzer, this court considered the situation when the initial doctor does not treat. In that case, it was a decision not to treat as opposed to an alleged negligent failure to treat. That's what we have here. They say we didn't treat hypercoagulability. And then the second doctor actively treats the second healthcare provider, and together the negligence creates an indivisible injury. It's up to the jury to decide if they're joint tortfeasors or initial and subsequent. And they have a tremendous burden to say, the judge made a mistake by letting it go to the jury and should have done it as a matter of law. I think they should have done it as a matter of law. They were joint tortfeasors because remember here, it was identical theories on the complaint and our affirmative defense. Hospital fails to timely diagnose and treat hypercoagulability and anticoagulate. JFK, exact same thing. Result, heart attack, loss of vision, and some neurological complications. Indivisible injury caused by exactly the same alleged conduct. This court in Letzer said, trial court does not err in letting that go to the jury. If there's another theory that the first doctor caused something that led him to the second doctor, that's one theory. If there's another theory that they combined to cause an indivisible injury, here vision loss that didn't occur until September at JFK, let it go to the jury. So I think they have not established error in the trial court letting that go to the jury. Thank you, Your Honor. Thank you.
As explained in my briefs, Lester is very easily distinguishable. And the case which they cannot distinguish are the other five, including Davidson. But let me talk about Lester. Lester was a case where a man had a problem with circulation in his toes. He went to one doctor. The doctor said, let's do a wait-and-see approach. Well, the wait-and-see approach didn't work. He ended up in the emergency room, and the doctor there had to amputate part of his forefoot. That same doctor also, in treating a different blood problem, which had to do with the blood flow between his hip and his knee, did a separate procedure unrelated to whatever had been looked at by the first doctor. That procedure went bad, resulting in infection and resulting in the need to amputate the man's knee right below the knee. There were two separate things that the subsequent doctor did in that case, only one related to what the first doctor had arguably been negligent about. That's why that case is distinguishable. And it goes into very much detail about this because that was the distinguishing factor that made it a factual question. If you look at Davidson, Davidson was a case where a woman had Hodgkin's lymphoma. She's treated. It seems to go into remission. She goes back for a CT scan. Radiologist reads it, says, I don't see any problem, you're fine. 2 months later, another radiologist looks at the same CT scan and says, there's a mass here, we need to look at this. Well, they go in, sure enough, it's a mass that's been growing, it was there. The surgeon does surgery. Unfortunately, he also cuts the carotid artery. She ends up dying, but that surgery was the result of the negligence of the radiologist reading that scan to begin with. And that is exactly what we have here. We have a CT scan, which the jury, CTA scan, that the jury found Bethesda's two radiologists did not properly diagnose a condition. Patient then ends up 4 months later at Good Sam, JFK. Everybody agrees, same condition. It was pulmonary, it was lungs, pulmonary embolism, same condition as the jury found them negligent of. There is no distinction between that and Davidson. Letzter, the second doctor, did two different procedures, one unrelated to the original negligence. That's why there was a factual question. The case law supports us on this as we've gone into our briefs, and there's a red light that says I have 16 seconds, but I think that means I'm over. So thank you very much, and we ask that you affirm on the main appeal and reverse on the cross appeal. Thank you.
Thank you.